Good morning, Miss. So now I'm going to present the land law video presentation. So my name is Chua Zhongwei. So as shown below, this is a question. First and foremost, I will explain what is a mortgage. A mortgage is a security of a loan. It comprises a transfer of a legal or equitable interest in the mortgagor's land to the mortgagee. The mortgagee interest shall end upon repayment of the loan with the interest and cost. The lender's contractual rights are supported by a proprietary interest in the land. This lasts only for as long as the debt remains outstanding, whereas the lender's remedies endure only for as long as the borrower owes money or mortgage is not extinguished. Moreover, the fundamental principle of the law of mortgage is that once a mortgage, always a mortgage. Once the loan is secured and has been repaid, the borrower has a right to have their land returned unencumbered. Then I will explain this case, Cheltenham and Gloucester Building Society and grant. So in this case, the court had no power to suspend an order for possession of a dwelling house made in favor of a mortgagee, except under Section 36 of the Justice Act 1970 and Section 8 of the Administration of Justice Act 1973. It was not the role of the Court of Appeal to lay down rigid rules as to how the judges should satisfy themselves whether Section 36 of the 1970 Act and Section 8 of the 1973 Act might apply. In such cases, it is accepted that a mortgagee is relying on its right to possession, and a court may deny or moderate such right only when employing some specific jurisdiction. So what Section 36 of the Administration of Justice Act 1970 talk about? If a mortgagee brings an action in court to recover possession of land which consists of or includes a dwelling house, whether as a prelude to sale or not, the mortgagor may avail themselves of the protection afforded by Section 36 of the AJA 1970. Under Section 36, an application made by a mortgagee for possession of a dwelling house may be suspended, adjourned, or postponed by court. In its discretion, if it appears that the mortgagor would be likely to able to pay within the reasonable period any sums due under the mortgage. Section 36 of the 1970 Act provides that where the court is faced with a mortgagor in default, the court may exercise these powers if it appears to the court that in the event of its exercising the power, the mortgagor is likely to be able within a reasonable period to pay any sums due under the mortgagee. In addition, Section 8 makes provision states that Section 36 applies notwithstanding the existence of an early repayment clause. In addition, possession proceedings will be issued against the mortgagors who can apply for relief under Section 36. The civil procedure rules now require the mortgagee to send a notice of proceedings to the property so that a tenant or other occupier would be aware of the proceedings. Furthermore, a borrower as mortgagor may hold a dwelling house in trust for themselves and their spouse or partner as equitable co-owners, or that spouse or partner may have a statutory right of occupation. Such a spouse or partner may not be a party to the mortgage, and possession proceedings may not directly be issued against them. In short, when acting under Section 36, the court has not power to suspend possession in the absence of evidence that the mortgagor is able to meet the shortfall between the proceeds of sale and the total debt from other sources. Now, what is considered as dwelling house? Section 36 only applies where the mortgage property consists of includes a dwelling house. Thus, if a mortgage affects only commercial or industrial property, it will not be caught by Section 36. However, if any part of the mortgage property can be classified as a dwelling house, a mortgagee action for possession of any part of that property is affected by this section. Moreover, there is no requirement that the dwelling house be occupied by the mortgagor. For instance, the mortgagee of a large office block would have to contend with Section 36 if there were a resident caretaker in the building. This has been suggested that it may be wise for mortgagees to exclude mortgages of commercial premises, such parts as are used as dwelling house, provided that this does not jeopardize the security. There are three solutions to prevent the mortgagee for seeking possession in the absence of default to prevent his succeeding. First, the mortgagee will not take possession unless and until the mortgagor is default. Second, within the court's discretion, the court can postpone an order for possession when a mortgagee seeks possession of a dwelling house. Last but not least, a mortgagee might be kept out of possession from the mortgage itself. Now we move on to Section 8 of the Administration of Justice Act 1973. Section 8 brought its own problems of interpretation in the shape of what type of loan repayment scheme fell within its term. Clearly, the standard repayment mortgage, whereby installments of capital and interest are repaid over a fixed term, are covered. The court has held that endowment mortgages are similarly included, but mortgages repayable on demand, which is common to secured and overdraft facility granted to provide funds to the borrower's business, do not fall within it. Whereby a mortgage of land which consists of or includes a dwelling house, or by an agreement between the mortgagee under such a mortgage and the mortgagor is entitled to pay the principal sum secured by installments or otherwise to defer payment in whole or in part. But provision is also made for earlier payment in the event of any default by the mortgagor or of a demand of the mortgagee. For the purpose of Section 36 of the AJA 1970, a court may treat as due under the mortgage on account of the principal sum secured and of interest on it only such amounts as the mortgagor would have expected to be required to pay, if there had been no such provision for earlier payment. A court shall not exercise by virtue of such Section 1 above the powers conferred by Section 36 unless it appears to the court not only that the mortgagor is likely to be able, within a reasonable period, to pay any amounts regarded as due on account of the principal sum secured, together with the interest on those amounts. However, if the interest on it there had been no such provisions as is referred to in subsection 1 above or for earlier payments. It will be noted that for Section 8 to operate, there are three conditions need to be satisfied. First, mortgage must affect a dwelling house. Secondly, the mortgagor must be entitled or permitted to pay the principal sum by installments or otherwise to defer payment. Thirdly, provision must be made for earlier payment in certain circumstances. In the case of Bristol and West Building Society and the Ellis, what is the fact? Mr. Ellis has fallen into mortgage arrears after her husband left her. She unsuccessfully applied for suspension of a warrant for possession on the basis that she would sell the property in half year's time. When her children had finished their full-time education, in support of her application, she provided estate agents' opinions showing that the likely sale price for the property should be sufficient to discharge the mortgage. Critical matters are the adequacy of the property as a security for a debt and the length of the period necessary, which shown in the case of Cheltenham and Gloucester Building Society and grant that we mentioned before. It said that before the court proceeds a sale which will discharge the debt, and the period within such sale is likely to be achieved. If the court is satisfied on both sums and the necessary period of sales is reasonable, it should identify the period in its order if the court decides to suspend the order for possession. It all depends on the individual circumstances of each case, though the important factors in most are likely to be the extent to which the mortgage debts and arrears are secured by the value of the property, and the effect of time on that security. Where the property is already on the market and there is some indication of delay on the part of the mortgagor, or maybe that a short period of suspension of only a few months would be reasonable, where there is likely to be considerable delay in selling the property and its value is close to the total of the mortgage debt and arrears. Therefore, the mortgagee is at risk as to the adequacy of the security immediate possession, or only a short period of suspension may be reasonable. So in this case, H.L.R said that the exercise of the power to suspend required that there should be some evidence, or at least some informal material before the court of the likelihood of a sale, the proceeds of which will discharge the debt. So based on the grant case, Mr. Dugan submitted that the material, formal or informal, before the district judge was insufficient to satisfy them that Mrs. Alice would or could sell the property within 3 and 5 years, or that its sale proceeds, when so, would be sufficient. Next case is a Ropai Gillette and Barclays Bank PLC. In this case, a lender taking possession of a dwelling house under a mortgage without recourse first to court action was not subject to the restriction of suspension of possession for those who did not apply to court. The lender will go to a court to obtain an order for possession, as this obviates any difficulties that might arise and is a quick and effective process. In the case of Abbey National Mortgages PLC and the Rocher Bernard, the plaintiff commenced possession proceedings against the defendant when the defendant fell into arrears with her monthly mortgage repayments. There was no prospect that the defendant would be able to repay the substantial mortgage arrears within a reasonable time or sell the property. In the case of National Provincial Bank and Lot, the issue is, could possession be postponed under Section 36 of the Administration of Justice Act 1970 so that the mortgagors could sell the property? There was no reason why possession could not be postponed for up to a year if it was clear that a sale would occur within this period, and that sale would pay off the mortgage loan. If the sale value would not cover the outstanding loan amount, a mortgagor could put clear evidence forward that he had assets, making it likely that he would be able to satisfy any remaining sum, and as there was only an intention to sell and no actual progress toward the sale, therefore, there could not be no postponement. Where there has already been considerable delay in realizing a sale of the property, or the likely sale proceeds are unlikely to cover the mortgage debt and arrears, or there is simply no sufficient evidence as to sale value, the normal order would be for immediate possession. In conclusion, the court needs to take account with the concrete evidence from the mortgagors to postpone of a possession order. Therefore, their rights will be protected in the future when they seek for a loan with the security of a mortgage. So, this is my bibliography and the legislation and the cases I used. And these are the journal articles and the textbooks I made reference to. By the way, this is the end of my presentation. So, thank you, Miss. Have a nice day.